of the, thank you for that, the final instalment of the Industrial Relations Society of Queensland webinar series for 2022. Our topic today is unfair dismissal, applications, conciliation or arbitration, what gives, by Dr. Andrew C. My name's Tony James. I'm a member of the Industrial Relations Society of Queensland Committee, and I'll facilitate today's webinar. I begin by acknowledging the traditional owners on the lands on which we are meeting, and I pay my respects to elders past and present. And I also acknowledge those of First Nations heritage who are with us in the webinar today. The IRSQ is recording today's webinar, and I'll shortly invite the IRSQ patron, former Deputy President of the QIRC, Adrian Bloomfield, to introduce our presenter, Dr. Andrew C. Dr. C will present his research on today's topic. And I invite you guys who are listening in to use the question and answer function on the Zoom toolbar to raise your questions throughout the session. And then Dr. C will address those questions at the latter part of today's session. The session will close on time at 1:45 p.m. today. I now call on Adrian Bloomfield to introduce today's guest presenter, Dr. Andrew C. Adrian.
Thank you very much, Tony. Andrew C is a well-known member of the Queensland Society, and he's been very active in the affairs of the Society for many years. Most recently, he was involved in a presentation role for the Advocates course that the Society runs annually. Andrew has studied and worked in industrial relations since 1982. He initially worked as an industrial relations officer with the Brisbane City Council before undertaking a range of roles within the Queensland public sector, including as Manager Policy, Division of the Workplace Health and Safety, and Manager Public Sector Industrial Relations. Prior to commencing work as a barrister at the Queensland Bar in 2004, Andrew was engaged as a consultant and then as counsel employee relations at Freehills between 2011 and 2020. And I didn't know this until I saw his CV recently. Andrew was a resident magistrate in the Republic of Fiji, where he sat on the Fiji Employment Tribunal. Today, he is engaged in a mix of consulting, advocacy, and academic activities, working throughout Australia and the Pacific. Andrew spends considerable time working in hands-on roles, assisting clients with all facets of industrial relations and human resources management, including enterprise bargaining. And he is very well learned, if I might coin an expression. He holds degrees in arts, laws, business administration, and philosophy, and has diplomas in industrial relations and business. And when I was a member of the Queensland Industrial Relations Commission, I can honestly say that Andrew was probably the most passionate advocate / barrister who ever appeared before me. He takes great interest and gets deeply involved in all of the work he does. And I'm sure that we're going to see how deeply he gets involved and the interest that he has in today's topic. Can I ask you to welcome Dr. Andrew C, please? Thanks, Tony.
Thank you very much, Adrian. I'm very pleased and honoured to be here today to speak to everyone in relation to this topic of Australian unfair dismissal. Let's get straight into it. The topic came about because, I guess, of my understanding that invariably when you rolled up to the commission or to a court, that the clients that you'd represent, particularly if you were representing applicants, employees, would come away disenchanted. And often I got the feeling that there was something missing and something that I didn't particularly understand what was going on in terms of this lack of satisfaction, if you like, with the result, particularly in terms of conciliation, but also in arbitrated cases as well. So when I wanted to eventually get involved in trying to learn more and pursue some studies in industrial relations, and this was the second opportunity I had. The first I didn't manage to complete the process, but it's important to understand, well, what do we need to look at first? What did we know about unfair dismissal in Australia that needed to inform the way in which you'd undertake a research activity? And so I picked out, and the paper that is available later on identifies, if you like, some key discussions about unfair dismissal and why it comes about, or the factors and influences. The first of these being Klaus, Brown and Henneman, which spoke about, well, what are the factors that determine whether or not someone is dismissed versus not dismissed? When a company is making that sort of decision, what are some of the influences? And there you'll see things like, well, is the labour available? So if we fired someone, is it capable of being replaced? Were there rules and regulations, etc.? So that was one of the first research pieces that I looked at. Later on, and much later on, even well after I'd started, I came across a research paper that was Justice Ross's thesis, and it looked at the factors which influenced the settlement of applications by conciliation, and it looked at things like the likelihood of arbitration success, the costs of trial, how much money the worker was earning was also a factor, whether or not they were going to settle or not at the time. And another key issue was the facilitation and intervention by the commissioners, whether or not they undertook face-to-face processes, and the degree of intervention and, I guess, influence they had as part of that participation process. In South Australia, another study by Meredith looked at issues of fairness, and it was very much in the time when state tribunals were doing unfair dismissal, but looked at the quality and consistency of outcome. And one observation was at that stage that it was very much influenced by a range of factors, including who was the conciliator who was presiding at the time. And that may have shaped, quantum result. Again, in South Australia, Hagland and Provis found that reinstatement in the system wasn't often a very viable unfair dismissal remedy, that cash settlements were small. And again, there in South Australia, at least, there was this notion that a perception that it was also influenced by the background of the commissioner and the experience, and this is another very important point, the experience of the practitioners and the way that they could work the system. When the research started to look at more the financial compensation side of it, Celli and Donetto found that arbitration didn't really bring significant compensation benefits. When you weighed it all up, you looked at the mathematics of it all, and that was an analysis of 342 arbitrated decisions in that period. Franz and Oslington, the same sort of thing. They looked at the impact of dismissal cost, and they looked at the outcomes based on a range of dismissal type, and saw that even where there was arbitration, it fell within that range of 1 to 4 months. And then there became an analysis by Professor Southey of Toowoomba, then I think, that looked at some of the personal factors, some of the behavioural issues that shaped why matters settled, what was happening, the impact of behaviour on arbitration. And one of the first issues that was looked at considered it from some of the reasons that an applicant might have relied on for indicating or eventually accepting that their behaviour did contribute to the dismissal decision. this report, which was commissioned by the Fair Work Australia back in 2010, when the report was ultimately released, was possibly one of the motivators for me as to that was consistent with what I was thinking. And this statistic at the time, and I think the important point to make is that this reflected the state of affairs 12 or so years ago, and I'm not suggesting for a moment it would still represent what's happening now. But 42% of the applicants who submitted to conciliation indicated that they weren't satisfied with the outcome that they secured. And some of the statistics, when you look at it, even give a more telling sort of indicator that there was this level of just, oh, look, it's just something that we have to do. Again, looking at the maths and the economics of it, there was a comparison done to see whether or not the Fair Work Act, as opposed to work choices, as opposed to the Workplace Relations Act, produced different effects, and whether or not the regime under one arrangement was better for workers. And it was, in case at least identified, probably that the Fair Work regime had a greater capacity to provide success for people, particularly when it included the small business category. Southey again looked at the contributory misconduct, looking at the behaviour of people and whether or not the tribunal would consider some factors that would be more or less influential in terms of offsetting for contributory conduct. It found that the least tolerance was in cases where there was some form of personal aggression at work, and that the tribunal was perhaps a little bit more tolerant in matters where, an employee might have been terminated for wasting resources or even employee theft, but certainly where there was some sort of notion of physical aggression at work, that was something that there was very little tolerance for. So that came to me. Here I was trying to work out, well, okay, how do you develop a thesis along those lines? I'd engaged with David Peets and Michael Barry, who were amazing in terms of the way in which they, helped me shape what it was to do. And so my research question was, are there some sorts of unfair dismissal cases that are less likely to be resolved by conciliation? What are the factors and influences as to why matters resolve at various stages? And then this last question of why do workers pursue arbitration to resolve these sort of unfair dismissal disputes? Now, because I was really interested in conflict at work, I also wanted to have this underlying theme to support that sort of analysis. And of course, workplace conflict, we know as industrial relations practitioners, is endemic in the whole sort of clash of the relationship. We know at the strategic level, at the industrial relations level, there's this sort of like broad notion of conflict. The literature, and it is quite a good read, there's plenty of work that's been done, more so in America than in Australia, but hopefully our work has sort of contributed to this a little bit. These other notions of conflict at work, task-based conflict, fighting about the organisation of work itself, and then at the lower level, what we say is personal conflict, relationship conflict, transactional conflict from the day-to-day. Now, just as an aside there, I do recall that when the first Australian Workplace Industrial Relations Survey was conducted back in about 1990, that it was one of the features of that survey that identified at that time of the influence that personalities, personal conflict at work contributed to industrial relations dissent in conflict at work. So that was also quite a useful theme to pursue. Now, at that time in 2016, we knew that about 15,000 people a year made application in the federal system for unfair dismissal. Of those, before they even got a staff conciliation, the staff conciliation is popularly known as the phone conciliation conference with the conciliators. Before even that stage, about 2,000 dropped off. At conciliation, about another 60% drop off. After conciliation, those that keep pursuing, there's still more, another 2,000 drop off. And even before hearing, or there's some other formalized processes to deal with issues, some more, we end up with, in that year, and it's probably reasonably indicative of around about 2% of cases end up going to trial to determine whether or not someone has been fairly or unfairly dismissed at work. So I hope you're all still with me. Now, what did we receive from the Fair Work Commission? The Fair Work Commission gave us the left-hand column. So all that we were provided with initially, and I'm still grateful that we were, but when I look at it back at hindsight, it was a little bit mean, but we were just provided with this first row of data. Here's your 326 case numbers. Okay, and so we were left with that. So the first thing I had to do was find these cases, read these cases, classify these cases, identify them, who's the commissioner, who was representing, who, the nature of the dismissal. So trying to then work in some notion of this workplace conflict and what was the outcome. Another way of representing that is, there you can see the left-hand column there was trying to rely on frameworks for dismissal, the cause of dismissal that had been somehow picked up in the earlier literature. And the reason for doing that was so that later on, when we looked at the results or wanted to sort of ultimately draw some conclusions, that we could try to find commonality in terms of either the language or the influence based on the earlier research that was undertaken. And there are the numbers of those different 11 types of dismissal category that we used, bringing you to that 326 total. Now, the next trick was, well, okay, needed to undertake, this was going to be a qualitative study, so I needed to find a sample of participants who could assist in trying to understand these research questions. Now, ultimately, this was the group that was formed. I'm amazingly overwhelmed by the participation and so grateful for all these members of the Fair Work Commission, the staff conciliators, everyone who participated was just absolutely wonderful. But I was really sort of quite taken aback by the participation from Fair Work. Some of the senior members, people that I admired from a distance, really famous sort of members, gave their time because they just saw it as being such a useful exercise. So ultimately from that 326, tried to find some sampling and representation amongst those people to interview. And the preference was to do face-to-face where possible. Well, that was achievable when they were from Brisbane, or in most cases in Brisbane. Majority of the work was done by telephone. It was digitally recorded, transcribed completely, and then redacted to provide at least anonymity in terms of the writing up of that. Each recording was about 60 to 70 minutes, and based on the different group, there was sort of this common theme of questions, but they were tailor-made a little bit based on the circumstances of who was called up. Just one thing going back here, it was initially intended at one stage to run some parallel paired cases, meaning, okay, you had a particular case and I'd get the applicant and the employer to give their competing perspectives about what went down. Now, because of the time lag and people start getting lost and people get reluctant to participate, that wasn't as easy as I initially thought. But luckily, I did get at least one story that I could write about in terms of, the perspectives of the parties. There's a couple of others that had common representatives, but in terms of the applicant and employer, there's only one good story in the thesis that I could rely on there. Now, the questions that were being asked in relation to, well, what happens from the time of a person being terminated to making these progressive decisions about, will I go to the Fair Work Commission or will I leave it go? I'm making an application, who's going to represent me? How am I going to go about? Are we going to resolve this before we get there? We resolve it at staff conciliation. No, we're not going to accept that. Keep going, keep going. So the 7 stages are represented here. And that's what the questions really focus on. Why here? What's happening at this particular point in time? What's different now? Why do you resolve at this point? Why do you think people resolved here and not there? Now, some key issues that sort of emerged initially, the first couple, if we just go to them, that the representatives thought that often the conduct of the parties, the strength of the case and commerciality are key drivers. Another view was, well, genuine redundancy, you can rule them out once you can shake the facts and people accept, well, yep, that might be in the case. The staff conciliators thought that often serious misconduct was easier to resolve, again, where you got that sort of like factual clarity and the concession being made. But the members in particular thought that serious misconduct was far more difficult to resolve where people are trying to clear their name. And that's something where people might want to pursue arbitration. These are the 5 key outcomes from the research, that the main factors why matters don't resolve by conciliation and why they do proceed. 1, matters of policy or principle. Now, this could be an employer, a large employer has a particular policy set that says, no, that sort of conduct we don't allow for, we're not going to compromise. This is the standard approach to the way we treat it. If we can't resolve it, if we can't get common sense out of it, we're going to pursue it. The principle might be a principle of, and the same deal could apply there if they're represented by unions. But the principle could also be a matter of principle. You often hear, it's the principle of these things. I'm doing this because, I'm not wanting other employees, to face this. Or sometimes I'm doing this because I don't want other employers to have to face it. They're the principles. The second issue is high level of emotion. Where there are high levels of emotion, where the parties are really, really upset, really cranky, there's less likelihood that they will resolve. And we'll come back to some of the issues about that soon. But that is a key influence as to why you can't get settlement, because people are just so frustrated, irate and angry. Where reinstatement is sought and you can't achieve that at conciliation, one side wants it, one side doesn't, well then obviously arbitration might be the only outcome that will achieve that scenario. People can have unrealistic expectations. They can just start the process on the wrong foot. They can think, nah, this is, we're right. And whether or not they've either been given advice or not, they still think, okay, I'm going to earn all this, or the employer thinks, no, I'm going to be vindicated by, my conduct, and they're just so off the mark. And the final issue is attitude and conduct of the parties. And I mean, you don't have to be Einstein, I guess, to realize that individuals shape, their behavior shapes the whole business from the time, you rock up in the first discussion with anyone in terms of the conciliation process or prior to discussion. If you're knocking heads or taking different sort of approaches which might be half smart or whatever, that can really influence those outcomes. Now, keep going just quickly with some other observations that have arisen. This is from the staff conciliators, but also participants. Sometimes they felt a little bit compromised by the fact that the window for conciliation is relatively short. By and large, it's a program for about 90 minutes. That seemed to be an issue. I'm not saying it's necessarily driving anything in terms of our outcomes, but it's just something that you need to consider. The role of the conciliator, this is the second issue here, was often not so much about convincing people of the merits of their case, but convincing them of the merits of trying to resolve something so that they can all get on with life. That's an interesting issue, I think. Another observation was just in terms of the way it all happens, you know, particularly these days when it's done by telephone, you have this shuttle and churn approach, you know, everyone gets to say their piece, and then you have this ricocheting of, you know, offers, and, you know, some people like that, some people don't. And then the question of how do you get representation in this, you know, there's a whole host of issues about should the person be self-represented, affordability issues, should lawyers be involved, you know, industrial advocates, et cetera, so they're all interesting issues that some of them are discussed in the research paper that I'll show. Ultimately, why arbitration? I've got about 2 minutes left. Why arbitration? It doesn't seem to make economic sense. That's one of the first continuous themes that emerges. The second is that even where you have arbitration, reinstatement only then takes place in about 10% of those cases. But there's a thought that perhaps it's not the remedy, you know, that it once was. And an argument there might be, you know, when the labour market's buoyant, and that goes right back to that early research in 1998. Well, when the labour market's buoyant, you know, people might be a little bit more sort of, you know, risque with their conduct and ability to go back and find another job. Arbitration addresses injustice often for the, you know, proponents. People want their day in court. Sometimes there's still this notion of an inflated view of success. There are some criticisms of this notion of an unfair dismissal factory, where people say that you've got these new players in the market who are causing grief because of the way in which they're bringing proceedings, and, you know, thinking that if you start something, you're going to get something. So every, you know, in effect, every child wins a prize. Other issues impacting on why arbitration, it might be some of the applicants may suffer from mental health issues and just cannot be, you know, steered in a way which otherwise, you know, might be seen as logical or rational. And occasionally people might be finding that the small town effect kicks in, where they're located in areas where there isn't much employment opportunity, and they don't have any other option but to fight for their reputation and their opportunity to continue working in a place which might be one of the major providers of work. So it really asks the question, can unfair dismissals be easily cured by compensation? That's obviously one question. It creates a whole new focus on the way in which self-represented applicants undertake and how they need to be treated and how you need to bring them along with the process. And I think the Fair Work Commission's done wonderful work in that area of, you know, providing that platform for people to be able to do that. The role of representative is a very important one. There's still issues about influence and characteristics of member, but I guess that's life. Anything involving people is going to, you know, be potentially exposed to, you know, claims and counterclaims there. But some of the key issues that arise, parties may not always be happy with conciliation, but they can live with the outcome. That's a very important point that's been raised. And there was earlier observations that sometimes comparatively the Fair Work jurisdiction doesn't seem to be able to provide the same sort of remedies as state-based tribunals, and that there might be a justice void in the fast tracking of conflict in that circumstance. That's just a diagram that shows you like sort of like some of those influences. In relation to conflict, last minute, it's important that we understand the sources of conflict. because if you understand the sources, you can have a bit of a different approach to the way in which you deal with the parties. Sometimes conflict's dressed up as something else. Sometimes it transforms from, a couple of those different approaches. Occasionally, people need more than one go to resolve it, so, don't get despondent if it doesn't resolve, the first time you attempt. Sometimes people need a cooling off period, another go at, and they, can slowly, the pennies drop or the, things drop, common sense drops. Another issue, it's important of resolving conflict by choice rather than having an outcome imposed. And that seems to be something which is a pretty important point that arises as a result of the research. There's no clear type of dismissal case more likely to proceed to arbitration. In the earliest stages, if you can isolate facts and achieve compromise, you'll get resolution. The latest stages, there's those influences, policy principle, the right to be heard. But arbitration is, for the most part, pursued for reasons other than money. That's the paper that arises as a result of the thesis. That's available on my website. I just thought, in case you want to access it, it's just an easy way of doing it. And the PowerPoints are also available there, although I'm sure that the organisers here would be able to mail them out to you as well. I want to just acknowledge a few people very quickly who've helped me with all of this. I'm very, very grateful to Michael Barry and David Peets in particular, but there's the influences in terms of the work I did: Ben French, Joanna McNeil, Ariel Adgar, Loretta Duplevitz, and then, of course, the participants from the Commission, Justice Ross for sponsoring the project, the interviewees, and some of the people who helped me in IR at the beginning of my career, Jeff Kenny, David Ray, Harold Anderson, and IR academics, Howard Gill and Glenda Strawn. I'm very grateful to them and my family as well. So thank you all very much. That's the end of the presentation. I hope that's useful, and I hope that you learned something from the presentation.
Thank you very much, Dr. C. That was a sterling presentation. I've got to say, thanks very much for it being so well structured. You really took us through from the background research of Southie, the Fair WA Commission's reports, Halia and Donito and others, right through to set the scene for your research question. And what a good research questions it was, and particularly through that lens of the parallel themes of conflict. I thought it was particularly enlightening personally about the characteristics of those cases that are likely to be settled or at least amenable to settlement versus those which have particular characteristics that just do not lend them to easy settlement. Just in terms of the PowerPoint presentation, IRSQ does record this session, and the PowerPoint presentation, I think, Andrew, would be posted on our IRSQ website for prosperity. That's great. There were some questions that have come through on the Q&A feature, and if you're okay, Andrew, I wouldn't mind running a couple of them past you, if that's okay.
Yes, of course.
Look, the first one is, I think we all recognise, I'm paraphrasing some of them because some of them were fairly long and wordy, but we recognise the value of the research in determining things like, I think the words were the personal inside reasons, personal outside reasons, and workplace related reasons, which may underpin unfair dismissal claims. Andrew, what would you say would be the follow-up work that could happen out of this research, sort of work that could be done to move forward with what you've already found, particularly around the areas of sources of conflict?
Look, I think that the issue of conflict resolution is one that can be viewed at either in a formal sense, so that when as practitioners we are exposed to it, we often, when we're considering it, or we're wanting to top up our skills and knowledge in it, we're looking at it in a very formal, structured way in terms of the formal notion of conflict, the courts, the legal procedures and all that. My take a little bit is that we have to start drilling into more the people relationship, the industrial relationship of work, so that when we are trying to resolve problems, we're dealing at it from that very much a people point of view. And I know that that's easy said, and I know, you know, like sometimes it sounds a little bit sort of, you know, twee, but those common principles that, you know, we've always heard about like respect, you know, like when you go into the room, when you have that first discussion, that, yep, even though, you know, the decisions fall in a particular way, someone's been dismissed, but when you front up and trying to resolve the matter, that there has to be this recognition of, okay, what's it like to be the other side? What's it like to be that person now? Why are they cranky? You know, from both perspectives. And I think that as practitioners, we need to get better at understanding all the sorts of stuff that goes with problem solving, with people relationships, with things like compromise, you know, with notions of fairness, all those sorts of personal attributes. That's the challenge, in my view, for people that, you know, I can just give the example in Fiji. Often when we'd start the employment situation, the same sort of thing, you'd have lawyers rock up and they'd be saying, as soon as they rolled up, they'd be saying, oh, well, look, I'd like 3 weeks or 4 weeks to file material. And you'd say, well, what's the case? Why are you, you know, in dispute? You've got someone who's lost their job. Tell us about. And they wouldn't be capable of telling you about. And I think that's the problem. It's about people. We're talking about people decisions, and we need to put our people cap on. And that doesn't, I mean, no one's got the, you know, it's not for HR professionals or lawyers or economists. We all are people and we all have that capacity, and it's drawing all sorts of skills to resolve the issues. So I would put the challenge up for the next lot of researcher to do that, to be looking at the skills and the capacity to be able to improve the way in which we resolve conflict.
Andrew, that's really fascinating, particularly in that dimension of people want their day in court sometimes versus no one likes a forced solution on them, or in fact, the forced solution can often be less than satisfying. I've got a couple more questions that have come through. A lot of them are about attitudes and perceptions about the unfair dismissal process. I'll go to a quick one, which is, what do you consider to be the starting point for invoking an arbitration in an unfair dismissal? Is there an arbitration clause that should be included in contracts of employment?
Oh, see, I think there's a public policy issue that you have to consider. The Fair Work regime, and the same in the state system, they are amazing. I mean, that they can produce, you know, the amount of resolution of these issues each year. So arbitration isn't the preferred way of dealing with them, and it's not the most cost effective. I guess, you know, government can only do so much in terms of providing this accessible forum, because if you didn't have this statutory relief, well, then what do? You'd have to go for a breach of contract. You wouldn't be going for an unfair dismissal in a common law jurisdiction. So I think that I wouldn't think arbitration clauses are the way to go, because the existing system doesn't allow for that, because they're not cost effective anyway. And if you take that approach to contracts, you're taking, I think you're taking a much more of, you know, an approach that we're not wanting to see. We're wanting to see employment contracts as a different category of case. And I think, you know, it's not like you haven't had, you know, 2 cartons of yogurt delivered, you know, and you're wanting to sue on that. It's very different. The notion of people contracting is very different. So I'd probably say no to an arbitration clause.
Happy with that. Nick, last question. I'm mindful of the time. It's been really, really useful. The question is what do you perceive to be the wider community's perception or attitude towards unfair dismissal protections, and in particular arbitration in this matter? Given that the findings are almost half of the applicants, I think you said 42%, are often dissatisfied with the outcome of an unfair dismissal case, does go-away money, which is a reality, go-away money, does that help or hinder the community's attitude towards this notion of unfair dismissal protections? Or does this notion tie to your observation earlier of the unfair dismissal factory?
Look, it is easier said than done. And when it's not your money, it's easier said as well. Like you can say, oh, can't you just give them, 6 weeks? Can't you just give them 8 weeks? It'll be all over and done with. Yes, there is some angst that causes, but there's commercial angst as well. You have to work out, at the end of the day, everything has a price on it. Is it go-away money? I guess if your policy and principled approach to arbitration, then you'd say, well, no, okay, well, we're not going to resolve on that basis. I think people at the end of the day often resolve and they're still happy, even though they might say, okay, I didn't like giving it now. I reckon like further on down the track when you ask them, well, would you have preferred to have had 5 days and had, 6 of your employees sitting around outside a commission waiting to give evidence? I reckon that life might change. People come away from the process. That 42% was dissatisfaction with the conciliation, not with the arbitration outcome. But I'd imagine that there would be sometimes people, because you get winners and losers with arbitration. Yes. But I still think if you look at it with some sort of period of time and reflection, even though you might come away cranky on occasions with conciliation, it's still often the better outcome than the other. So yeah, go-away money is always going to be there, but it's a cheap line to give at the time. But I reckon like a couple of, everything with time and a bit more wisdom, you might sort of moderate the way in which you, describe that. Good question, but.
Thanks very much, Andrew. That's excellent. Look, I see we've got basically, I think, 2 minutes left. What I might do, rather than bring on another question, I might just bring the seminar to a close. Andrew, if that's okay. I truly do wish to thank you for your time and your effort and for sharing the research that you've done. I know you've put your hand up to maybe come back for our 2023 webinar series and give us a bit more of a talk about the Fijian experiences or the compare and contrast, which I've actually mentioned to a couple of my colleagues. And yes, that actually has a lot of interest amongst the IR practitioner community. I thought it was an informative session and a very entertaining session. And I look forward to being back with you in the 2023. Just a couple of other housekeeping matters, if I may. The annual general meeting for the IRSQ is held on this Friday. I think registrations may have closed, but if you're desperate to still get in, I think send a message through on the website. But I would ask for those members who are intending to use or to provide proxy vote arrangements, if they could get those proxy vote arrangements sent through to the secretary, IRSQ secretary. The email address for the secretary is on all the information that's come out regarding the annual general meeting, and I believe it's also on our website. On that, I wish all our members and all people who are on board today a very happy, safe and prosperous Christmas and festive season and into 2023. There will be a survey coming around. Who doesn't have a survey? Who doesn't love a good survey? There will be a survey coming through on this webinar. We would ask that attendees do complete that, send it back to us. It does certainly inform us into the value of this seminar and how to improve or continue the value of these seminars. We found these seminar sessions this year to be very, 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 very positive, very, very good. My watch is about to tick over in 10 seconds to 1:45. I think we've timed it perfectly, Andrew. I do very much appreciate your time. I wish everyone all the best. Daniel, if you can pull the pin on the session, that would be wonderful. Thank you very much.
Thank you, everyone. Okay, bye-bye.